If you watched my last video, then you know that if you're going to a Taylor Swift concert, you need to make sure to have your durable financial power of attorney in place. But you may be thinking, Gregory, I like Taylor Swift, but I probably won't be going to one of her concerts anytime soon. Do I really need a durable financial power of attorney? First of all, you monster. She's a national treasure. Second of all, there have been times in the past where people needed a durable financial power of attorney even when they weren't going to a Taylor Swift concert. I know, right? So the question really is, should you have a statutory short form power of attorney or a common law power of attorney? If you don't know what I'm talking about when I say statutory short form power of attorney and common law long form power of attorney, watch my previous video. It'll make the whole Taylor Swift thing make a lot more sense. But for now, my name is Gregory Singleton. I'm an estate planning attorney with Signature Law, and we're here to talk estate planning. As part of our Essential series, today we're going to look at the difference between the statutory short form power of attorney and the common law long form power of attorney, and specifically, what are some of the strategies that you can use when doing your durable powers of attorney to make sure that your needs are met to protect your legacy. This is video of 2 of 2, and here we go. To recap very briefly, the statutory short form power of attorney is a form that banks and financial institutions are obligated to follow. However, the terms of the statutory short form power of attorney cannot be custom tailored, either the authorities granted or any of the terms of the power of attorney. The common law power of attorney is any power of attorney drafted under Minnesota law that is not a statutory short form power of attorney, meaning that it can be rejected by financial institutions and banks. However, you can custom tailor all of the terms. Now, I'll tell you, most attorneys that I've worked with have said you gotta have the statutory short form power of attorney. That's just the way they think, that's just the way it is, and it's not really strategic, and I don't think it's meeting your needs. Today we're going to talk about approaching the question strategically so that make sure that your needs are met. So strategy 1, let's just hop into it. The most common one is using the statutory short form power of attorney only. You get all the protections of the statute, but you get none of the protections of custom tailored drafting. Now, when people do this, I do tell them, don't distribute the power of attorney. Don't give it to your attorneys, in fact, ahead of time, no matter how much you trust them. Put it in a safe spot, send them a letter saying that you've been appointed as attorney, in fact, this is what it means, don't abuse it, and if you need it, only use it if I'm incapacitated, and if you need it, go into my file cabinet in the back room and pull it out and then use it. And you have my permission to do that. That's strategy 1. Strategy 2 is use a common law durable power of attorney with confirmation. Now, you thought strategy 2 would be just using a common law power of attorney. That's not really a strategy. So what I mean by with confirmation is you get pre-approval from various financial institutions that you work with that they will accept the language in your common law power of attorney. Some banks won't touch non-statutory short form powers of attorney. They will not touch the common law power of attorney. But what you can do is if you work with another bank that might, you can say, hey bank, I'm going to use this form. Can you approve it? Now, one of 3 things will happen. 1, they'll say no. 2, they'll say, we have our own form, you got to use that. Or 3, they'll say, yeah, it's fine. I guess there's 4 things. Yeah, that's fine. Or 4th, they'll be like, you know what? We're fine with it as long as you include like this language. Oftentimes it's like an arbitration clause. And if you're willing to do that, they'll accept it. The downside of this is if you have to work with a financial institution that you did not get pre-approval for, or you have to work with a government agency that might reject the non-statutory form, or an insurance company, then you got a problem. Strategy number 3 is to use both with spousal priority. And what do I mean by that? You do a common law power of attorney and a statutory short form power of attorney. And the statutory short form power of attorney is for only lists your spouse as the attorney in fact. The common law power of attorney creates 2 conditions. 1, your spouse is unable to act. 2, you are deemed incapacitated. That way, at least for part of it, you get the full protections of the power of attorney under the statutory form for your spouse, the most likely person that's going to need the power of attorney. But if something happens to both of you, you still got that common law power of attorney in place. I would still do the confirmation with this, by the way, for your common law powers of attorney. Strategy 4, use multiple powers of attorney with varied authorities. Now, what we've really discussed in strategies 1 through 3 is having an all-encompassing power of attorney that is for all transactions. What we're saying here is you could use one power of attorney that only authorizes, let's say you're going to use both statutory short form powers of attorney. One of them, for your spouse, for example, authorizes use of all powers under the authority, all 13 enumerated powers under the durable power of attorney statute. And then for your successor powers or attorneys, in fact, you say you only can do banking transactions. You cannot sell the real estate. Now, that's one of the main things that I run into. What people want is they want their attorneys, in fact, to handle their affairs, but don't sell the house, don't sell the cabin, don't sell the real estate. And then this is one way that you can do it. You just have to have multiple powers of attorney in place. The one that's general, you just don't put successors on it. Strategy number 5, leave instructions. One of my favorite strategies of all time, though a little bit untested. What I mean by leaving instructions is think of the healthcare directive to start. Under the healthcare directive, we inherently leave instructions for the healthcare agent to follow. They have to follow your instructions. And it's called the living will. And it says, for instance, if I'm in a persistent vegetative state, after 1 week and 3 days, pull the plug. Or whatever it may be. And it should be much more comprehensive than that, but you get the idea. For the durable power of attorney, we don't include instructions. But can you? And what does it do? Well, remember, your attorney, in fact, is your fiduciary. They have to be acting on your behalf, even if it conflicts with their own interests. If you were to write a letter and make sure that your attorney, in fact, gets a copy of it that says, if you need to use a durable power of attorney, I do not, in any way, shape, or form, want you to write checks over $2,128 to anyone. Do not sell the cabin, but you can sell the house and you can write checks under that amount, or whatever stipulations you want to put in there. Are they acting on your behalf if they violate that letter? Maybe. I would say probably not. And I would say that it's certainly strong evidence that they're not acting on your behalf if they're using the power of attorney. And if they go against your instructions, they're probably misusing it. So that's one way that we can kind of turn a statutory short form power of attorney into one with some specific terms. A court may disregard it. I don't know. I can't find any courts that have dealt with this question. But it's an interesting strategy, and I do like it. And I do recommend anyone that is doing a power of attorney to leave instructions for your attorney. In fact, at least tell them what bank you work at, right? Or not work at, but you work with. Strategy number 6 is using third-party storage. We've used this strategy a number of times with people that, for instance, their son or daughter was appointed attorney in fact years ago, but the son or daughter is abusing the attorney in fact, or the durable power of attorney. What using third-party storage is you rescind all prior powers of attorney, and then you draft a new one, and you give it to a third party, such as a law firm or some other fiduciary or maybe a friend. And the law firm or fiduciary or the third party has instructions to not allow anyone to have a copy of the durable power of attorney until they show you proof that you are incapacitated. Remember, with the statutory short form power of attorney, we cannot make it springing, not inherently, not within the four corners of the document. But if you prevent someone from having the document, unless you are incapacitated, you've gone over that hurdle. You just got to find someone to act as the third party, and not everyone will do that. The 7th strategy that I've come up with here, there's a few others out there, is to use a revocable living trust. And what that means is if you become incapacitated and you have a revocable living trust, then the successor trustee will take over and handle the trust assets. If you've set things up properly, the trust assets will include all of your assets. So they'll be able to pay bills. They'll be able to do this, that, and the other thing. They'll only get to take control if you become incapacitated. You can put in whatever terms you want to restrict them in your revocable living trust. And for some reason, financial institutions and banks will honor a revocable living trust faster than they will a durable power of attorney, in my experience. Now, the downsides of this is that a revocable living trust only authorizes a successor trustee to address the assets or manage the assets in the trust. It doesn't give them authority to, say, work with insurance, to, say, work with government institutions, say, to work with anyone else or an asset that you forgot to put in the trust. Also, one common strategy that we use for funding a trust with a house is we'll use a transfer on death deed, so that the house stays in your name until you die, and at your death, the house transfers into the trust. Well, until you die, the house is not in the trust, and the successor trustee has absolutely no authority to do anything with it. So if one of the things that may have to happen when you become incapacitated is that your house may need to be sold or something along those lines, then you're going to need to have a durable power of attorney anyways. So a lot of what we've talked about is getting around a stinky law. The Minnesota durable power of attorney law is terrible. It makes me angry on a regular basis. I can see why we have both sides. Banks want something that they don't want to have to be put in the position of determining whether someone is incapacitated, and they don't want to be in the position of interpreting new terms that other attorneys might come up with, or language or stuff. It could lead to a lot of court cases. However, the protections that we lose under the Minnesota statutory durable financial power of attorney, in my opinion, are egregious. And I hope in my career that this is ended. One final thing. All these 7 strategies, you can mix and match. You can do a revocable living trust along with statutory short form power of attorney that has been confirmed with your financial institutions. You can leave instructions for any financial or durable financial power of attorney that you have. Work with an attorney that knows what they're doing, that's willing to work with you on this. Not all attorneys are. To make sure that you develop a strategy, an incapacity strategy that works for you and meets your needs. The goal is to protect your legacy. That's it. So make sure you get what you need. Powers of attorney are a vital part of estate planning. Remember, it's your estate plan. Think strategically. Find an attorney that will do the same. I hope you liked today's video. If you did like today's video, hit that like and subscribe button. Really helps support the channel. We do videos every other Wednesday. If you have a question, leave them in the comments below or send me an email. Otherwise, until next time, this is Gregory Singleton with Signature Law.